Good morning, you're near Benur.
Yes, I am.
And Mr. Benur's case is set for trial. This is 22-40828, Monday, the 1st of December. And what is the announcement?
Judge, we're ready.
State your agent.
With regard to the issues that we began discussion of, and I gave some time for Mr. Gertz to be able to reach out with investigation on other complaining witnesses, has all that been taken care of?
From our standpoint, Judge, we've had no ability to get anyone to speak with us.
Okay.
So that's, I mean, that's their choice, you know,
Sure.
obviously, but we've made the effort to
Okay.
have that done.
So what I need to do then is prior to that Monday, make a ruling. Probably set that, we probably need just a little bit of time for them to,
I think one of the challenges I have, Judge, is I think I'd like to, what we had, just my recollection is what we had last time was essentially a proffer by an investigator, just proffering what other people said.
right,
But I don't feel like we have the details, sort of police report level details from any of these allegations, if you will, that so I guess I just feels like that would be discoverable, whatever the state has in their possession about these
have there
interviews.
been any,
There are no written statements, Judge. We made, in fact, I don't know that we were even under an obligation to give as much detail as we gave. We gave him notice of these witnesses that they exist and the nature of what their testimony might be. But the short answer, Your Honor, is there's been no written statement.
and have they talked with just investigators, or have they talked with detectives from other agencies, or just within your office?
Just within our office,
Okay.
to the extent that I'm aware of, Judge.
Okay, so there aren't any police reports or anything like
Not
that?
that I'm aware of.
I think what I'm going to need to do, and I know I made some pretty detailed notes when we were here before, is make obviously the ruling on which, if any or all, I'm going to allow. And so, here's my notes, look at that. I don't know that I need, if there is no other, so there were 4, correct? We used initials. We had an initial of SM, which was a 2000 case, tummy tuck. There was some pretty detailed information that was given on that one. There was MN, which was a 1992 sinus issue with some other issues that came to light that time. And then we had a TK that I think had become now a TR from 2022. Also some details about that one. And then an RD from 2015 was a tummy tuck. Oh, and then one more, but that one hadn't been contacted back. In RL, is there any notation that that one is, so,
We
okay,
have not had any subsequent contact with RA.
all right. So, if there is no other, if there aren't any other police reports, and the, do you want time early one day this week to actually have an argument hearing? Do y'all just want me to make my decision based on what I have?
I think it'd probably be better to do it written by submission and let the court rule on it next week sometime.
Okay.
I don't have anything additional to add. I'm okay with the court just making a ruling.
Is that your phone?
The answer is yes. I'm okay with the court just making a ruling without any additional argument. Just make sure it's all completely off.
Yes.
Okay, so what I'd like is if you guys will get that, anything written. I think Mr.
think I gave
You
the
already,
copies.
you already did, I'm pretty sure. And so what I'll do, if you want to have anything to add to yours, you're welcome to do that. And then if you just want to do a response in writing, I would really like that, if possible by Thursday, or you in trial this week, by Thursday of this week.
I'm not in trial now this week.
I'd like to make that ruling before the end of this week so that you all know while we're off next week what to be preparing for. Anticipate this will be the number one trial, obviously. I think we've talked about that and making it special setting because of the age and the fact that we've already gone through it. So I want to make that ruling by Friday. So I'll be around. Obviously, I'm in trial, and I'll make that and give it to you guys by email or by an order. Okay?
Yes, Judge.
Judge, the court has already ruled previously in a previous hearing subsequent to the trial that the court would allow this case to be off of YouTube. We just reminded the court of that decision that I believe was made a while back, and asked the court to do that once we begin trial on the 1st.
Did I?
I don't recall that, Judge.
Why would I have done that?
I believe.
I mean, you may have asked for it, but I don't remember saying that I would. I think if the complaining witnesses have an issue, then I would be, if I recall, I don't remember, I thought it was this case where I talked about potentially during certain testimony, blurring it out or blacking out certain things, but I don't, if you want to do something, a brief in writing, a short, something about what your request is and why, I don't recall actually or saying that I for sure would not do that. That doesn't, I remember maybe having the discussion, but I don't remember saying for sure I would.
And just I think the facts for this case are distinguishable from the typical case where.
Sure. I mean, I never put child
Yeah,
cases
okay.
on, and typically I primarily leave it up to a complaining witness or something like that, who's disclosing, private certain information. But I will take what you have to say into consideration. If you will also reach out to, I think the complaining witness, I mean, we had it on last time. If she's still okay with that, at least just shoot me an email and let me know, and then put whatever you need in writing, and then I'll make that decision when it gets a little closer.
Okay.
Anything else that you guys know of that we will need to address pre-trial on this one?
Not from the state judge.
Okay, all right, then I'll make that ruling again on those additional witnesses by Friday.
Okay.
All right, stay in touch with Mr. Gertz. He'll let you know when you need to be back. And then, Mr. Gertz, you have a Jonathan Zcaff. All right, so you're Jonathan Zcaff. And this is 24 DCCR 2348. Mr. Zcaff's case is set for trial also to begin with jury selection on December the 1st. Announcement.
It's pleading to a lesser included.
Oh, it's right here. Gotcha. Hold on. I need to look at too many things. DW, a second. Okay. Let me get that pulled up. Mr. Gertz, will your client waive the formal reading of the indictment?
You will, Judge.
Mr. Galvan.
All right, Mr. Zcaff, the state has elected to proceed. So it would be on the April 10th, our date, and then just one prior. So it would be paragraph 1 and 2, correct?
Yes.
So it's not really counts. Okay. So the state's elected to proceed on paragraph 1 and 2. It alleges that you committed the offense of driving while intoxicated April 10th of 2024. The indictment further alleges in paragraph 2 that you were previously convicted of driving while intoxicated January 16th of 2019. And how do you plead to that charge? And is that prior conviction true? Did you enter your plea of guilty and true freely and voluntarily? And because you did what they charged you with? I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Gertz? Do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal? And it looks like the agreement is for a 1-year term in the Jefferson County Jail, but that would be probated for 2 years. You would be ordered to pay a $2,500 fine, follow all of the rules and conditions of probation. Also, part of that is that you would serve 10 days upfront time, and you would have the interlock device for that entire, well, for the first year of your probation. Is that your understanding? I do want to make sure you understand that conditions of probation are up to me. If for some reason after that year, I feel like it would still be necessary for any reason, if there's been any hiccups or anything like that, it could still be ordered by me after that period, regardless of what you guys have agreed to. Do you understand? Okay. State tenders number 1.
We have no objection, Judge.
It's admitted. And sir, are you a U.S. citizen? And is there any evidence that Mr. Zcap is not competent?
No, Judge.
So are y'all ready? Do I need to get a report? Are we?
We're
See-
ready to proceed, Judge.
All right, so I'm going,
And
is
then we
there,
have one caveat regarding the upfront time.
that's what I was gonna get to. So what's that?
We're asking that the court allow him to do the 10 days on 5 successive weekends, starting on November 28th at 6 p.m., please.
Any issue with that? All right, so I'm going to find that you, again, entered your plea of guilty freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time, find you guilty of the driving while intoxicated second, a Class A misdemeanor. Sentence you in accordance with your agreement to a term of 1 year in the Jefferson County Jail, but I'm going to probate that, and you'll be on probation for 2 years. You're ordered to pay the $2,500 fine and to follow all of the rules and conditions of probation. You will be ordered to serve 10 days up front. That will start on Friday, November the 28th at 6 p.m. And then you will go every weekend until those 10 days, for 5 weekends until those days are served out. It's important that you're on time for that, 6 o'clock. If you're late, it could be a violation of your probation. Do not show up under the influence of anything. Some people think they show up, they're gonna do whatever and get there and sleep it off for the weekend. Bad idea. You'll be right back in here on a motion to revoke your probation. You are required to have the auto ignition interlock device for sure for that first year. And then if everything goes fine, obviously that condition would go away as well. If you follow all of the rules and conditions and do everything you're supposed to, then for all practical purposes, your case here in court is over. You'll be able to serve that 1 year sentence while you're out on probation. The other side of that is if you violate any condition of probation, you could be brought back into court and you could be sentenced to that 1 year term that you've already agreed to. Do you understand? Yes. I'm going to hand you the trial court certification. Shows that this was an agreement that I followed, and so you've waived your right to appeal. It is a long ways to go from here to there. You need to have a seat once I give you that document here in the courtroom. Probation is sitting at that desk right over there. She's going to call you up when she's ready to go over all of your paperwork. All right, good luck to you, sir. Thank you, Mr. Curtis, Mr. Smith. Good morning, ma'am. Are you Catherine Jordan? And Mr. Crenshaw, will your client waive the formal reading of the indictment?
We do, Your Honor.
Yeah, the state would be proceeding on the lesser included state jail amount of $2,500 to $30,000 instead of what's stated in the indictment.
That is correct, Judge, and we're also prepared to waive a PSI.
Okay.
Your Honor,
Do y'all?
and just for the court's benefit, just really briefly, the defendant has agreed to pay some $24,000 in restitution up front. Mr. Crenshaw has a cashier's check here in that amount for the complainant in this case. There are some other extenuating circumstances that has led the state to enter into this agreement, Judge.
Okay.
And if the court is inclined to waive a PSI, which the state's not opposed to, just in a full candor with the court, Judge, there is some past criminal history, but that has been some time ago, and I'm happy to go into more detail if the court wishes.
If you're okay with it, Mr. Coleman, look, and especially with the fact that the victim will get payment, it looks like upfront.
Yes, sir.
And
It's an
that's in
HOA.
full, correct?
Yes.
And what was that amount?
24,000 is,
Just to be clear, Judge, it's not the full amount of restitution that was claimed. I think the full amount was in the neighborhood of $36,000. Mr. Crenshaw has provided the state with some mitigating evidence in the form of some receipts that I don't question the veracity of, that would mitigate down the $36,000 figure to $24,000.
Okay, thank you, thank you. All right, so will she waive the formal reading of the indictment as modified?
Yes, Your Honor.
Ms. Jordan, in cause number 25 DCCR 0440, the state has elected to proceed on the lesser included offense of misappropriation of fiduciary property between the amounts of $2,500 and $30,000. That's a state jail felony again. And that is from February 26th of 2025. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they've charged you with? Speak up, please.
Yes, ma'am.
I have here on the tablet some documents that should have your signature on them that the state has marked as exhibit number 1. Before you sign these, did you go over them with Mr. Crenshaw? And do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal? And it looks like the agreement that you've reached is for a 2-year term in the state jail prison. That would be probated. You'd be on probation for 5 years. You've agreed to pay restitution, which it looks like is being paid today in the amount of $24,000. That you will serve 2 weekends in the Jefferson County Correctional Facility in December 5th through 7th and 12th through 14th, and follow all of the other rules and conditions of probation, including not being employed anywhere involved handling cash. Is that your understanding? And are you a U.S. citizen?
Yes, ma'am.
State tenders number 1.
No objection.
It's admitted. Any evidence that Ms. Jordan is not competent?
No, Your Honor.
All right, ma'am, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. With everyone's agreement and with what Mr. Coleman has told me today, I am going to waive the pre-sentence report and find sufficient evidence to find you guilty, and at this time find you guilty of the state jail felony offense of, well, is it theft or misappropriation?
We're still going with the misappropriation
Okay.
on a lower value level.
Gotcha. So misappropriation of fiduciary property, and sentence you in accordance with your agreement to a term of 2 years in the state jail prison. I'm going to follow the agreement and probate that. You'll be on probation for 5 years. You are ordered to follow all of the rules and conditions of probation. That includes paying the restitution today of $24,000, not being employed involving any cash. You will serve 2 weekends in the Jefferson County Correctional Facility. That will start on, the first is December 5th. Both of those, the second weekend is December the 12th. You are to be there at 6:00 p.m. It's important that you're on time. It's also very important that you're not under the influence of anything when you show up. If you do everything that you're supposed to while you're on this probation, then for all practical purposes, your case here in court is over, and you'll be able to serve that 2-year sentence while you're out on probation. The other side of that, however, is if you violate any condition of probation, you can be brought back into court and you would be facing that 2-year sentence that you've already agreed to. Do you understand? I'm handing you the trial court certification. That's not it. I am going to hand you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I'm also going to hand you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term. You should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Crenshaw. And so if you'll just have a seat here in the courtroom, probation, she's at that desk right over there. Watch for her to call you up. She'll go over all of your paperwork. Nope, you're good. All right, thank you.
Judge.
Thank you.
Thank you.
Would you mind printing out one and I'll do the other, please? I'll do the first one. I'll do the 19 case, if you'll do the 20. Give me just a second. You're Janisha Leonard?
Yes, ma'am.
You need me to do it? Did you get to it yet?
Yes, ma'am.
Oh, okay. Uh-oh. The Unity print spooler has stopped working. Okay, Ms. Leonard, in cause number 25 DCCR 0297, you're charged with the state jail felony offense of theft of property from August 24th of 2024, continuing through September 4th of 2020. That's not right. 23, we can't go. I think the dates are,
It does appear to be off, Judge, I apologize. Let's see.
I mean, do you want to just pick one? I don't think it,
It should read August the 24th of 2023 through.
okay. September 4th.
I'd make a trial or a motion to amend the indictment, Judge.
Any objection to that?
What would the new date be?
Change the first year to 2023.
And they would both be in 2023, yes, ma'am. No
Correct. All right, let me, hold on a second, let me get that pulled up. Okay, so let me make that. Sorry, y'all, give me just a second. Okay, so what you're charged with is theft from August 24th of 2023, continuing through September 4th of 2023. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they charged you with? I have, in that case here on the tablet, some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas? Do you fully understand them? And it looks like there is no agreement in this case, is that correct?
That's correct.
That's correct.
And so you're leaving your punishment in this case up to the court. You do have some rights to appeal. I want to make sure you understand, y'all signed the post-conviction waivers. Do you want me to mark through those?
Please.
Please, Judge, thank you.
I want to make sure you understand, you have an absolute right to have a jury come in and determine 2 things. The first is if you're guilty or not, and then you could leave punishment up to that jury if they find you guilty. If we go forward this way, you're leaving your punishment up to me. Is that what you want to do? Do you also understand if you're not a U.S. citizen, a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Ms. Leonard's not competent?
There you are.
All right, ma'am, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case so that the probation department can do a pre-sentence report. That'll give me more information about you and your case, and then we'll come back later for sentencing. So then, on that indictment, I did make a modification, like in the, it's not at the top, it's, I did a strike through and it's in the body. So see if it works right. Give me. I'm not sure if it's showing up well, but okay. And then we have cause numbers 19-33340 and 20-36095. And will your client waive the formal reading of those motions?
She will, Your Honor.
In each of these cases, I have motions to revoke your community supervision. It looks like both of them Well, in cause number 33340, you were placed on probation April 7th of 2021 for the offense of theft of property, a state jail felony. That was a 2-year sentence that was probated for 5 years. Is that correct? And then in that 36095 case, you were also placed on probation April 7th of 2021, and this one for theft of service, a state jail felony. That was also a 2-year sentence that was probated for 5 years. Is that correct? Each of these allege you violated your probation. Count 1 alleges that you committed that new offense of theft August 24th of 2023, the case that we just went through. And is that true or not true? Count 2 in each case alleges that you did not provide verification of performing the community service hours as required. And is that true or not true? And then count 3 in each case alleges that you are behind in your court-assessed fees and probably restitution in each of those cases. And is that true or not true? Did you enter your pleas of true to counts 1, 2, and 3 in each of these cases freely and voluntarily? And did you plead true to those counts because they're all actually true? All right, I'm going to find that you entered your pleas of true to counts 1, 2, and 3 freely and voluntarily in each case. Find sufficient evidence in each case to revoke your probation. However, I'm going to reset your cases and get the probation department to do an updated report. Again, that'll give me more information about you, your probations, what's going on, and then we will come back later for sentencing. And these are unagreed, correct?
That's correct.
Anything that you think is important for me to know, make sure you get that information to Mr. Rojas. He will present it to me on the next court case on your behalf. All right, do you need her? Okay, if you'll stop and talk to probation on your way out of the courtroom, please. Nope, just go talk to her over there. Over there it did? It just. Good morning, sir. What's your name, sir?
Yes, my name is Michael Chavarria. I'm here on behalf of Alex Comerford.
Travaria?
Chavarria,
Chavarria.
Chavarria. It's a hard name, yes.
No, that's okay. Thank you, Mr.
I
Chavarria.
apologize. He's in trial today, so.
Okay,
I'm
thank
happy
you.
to fill in for him.
Appreciate that. And sir, you're Jace Dunn? And Mr. Dunn is charged with solicitation of prostitution. And Mr. Chavarria, what is the announcement on that?
Yes, Judge. We've received an offer. We conveyed the offer. We're just asking for one more reset to give Mr. Dunn an opportunity to make his decision.
Sure.
On this case.
Any issues that you have notated?
No, Your Honor.
So I'll just do a normal reset. Mr. Dunn, stay in touch with your attorneys. They'll let you know when you need to be back. If you have any questions, visit with them about that offer so that when you come back, we can either take care of that or get it moved to the trial docket. All right, you're free to go.
Thank you, Judge.
And then you've got Simon Gobert. Good morning, sir. You're Simon Gobert?
Yes, ma'am.
And this is 24 DCCR 0512. Mr. Gobert is charged with attempt to commit sexual performance by a child under 14. And what is the announcement?
Yes, Your Honor, we've received an offer on this one. The defense is requesting the opportunity to file a motion, make a motion in this case. I think that'll put us in the best position to advise the client how to move forward. We're asking for another reason on this case as well.
This case is so old. Let me see what's been.
It was re-indicted a few months after it was initially indicted, and then I see notations that they've been discussing. I think that the cap offer had been made recently, I believe, but.
So it
That's my
looks,
understanding.
all right, it looks like your office was hired back in June of this year. So obviously those things should have been done prior to today. I will do a normal reset. So whatever needs to take place, make sure they get that filed immediately.
Yes,
Because there's probably, we need to get an announcement at that next court date.
Okay.
Okay.
I'll let Ag know. Thank you, Judge.
Mr. Gobert, please, stay in touch with your attorneys. They'll let you know when you need to be back. All right, you're free to go. And then Ronnie Oliphant. Good morning. You're Ronnie Oliphant.
I am.
And this is 25 DCCR 0379. Mr. Oliphant is charged with injury to a child, elderly, or disabled individual. And what is the announcement?
Yes, Judge. Essentially the same request, Your Honor. We received an offer recently. We confirmed that that was the best offer. We conveyed the offer to Mr. Oliphant, and we're respectfully requesting one more reset to allow him time to make a decision.
The state's not opposed, Judge.
So, Mr. Oliphant, I'm going to reset your case. This will be the last reset. So you need to visit with your attorney, family, whatever you need to do about what that offer is at the next court date. Either take that offer or we'll get your case set for trial. Okay, you're free to go. Thank you. Thank you, Mr. Chavarria.
Yes, ma'am. And we have one more, Mr. Tippett.
Oh,
for
you
sense,
sure?
but
Good morning, sir. You're Brian Mitchell, Senior. And 24 DCCR 0170, Mr. Mitchell's charged with aggravated sexual assault of a child, case set for jury selection on Monday, December the 1st. And what is the announcement?
We are ready, but the court would know that following Monday.
Yeah.
We can't get it settled. So I would ask for some consideration.
Sure, and we do have, there is an older case that is set number 1. Is the state ready?
Yes, Judge.
On
Looks
Mr.
like
Mitchell?
all the motions were filed and equal.
Okay, I'm going to number it, but I'm going to take into consideration.
Push comes to shove, Judge,
But I do understand what case you have the week following and that there will be some preparation on that one as well. And if something happens, obviously in our number 1 case, we'll see what the order is. Mr. Mitchell, stay in touch with Mr. Burbank. He'll let you know what that trial order is and to be back on December 1st probably, okay? All right, we'll see you then. Yes, thank you. Hey, Tom. Good morning, you're Tate Daly?
Yes, ma'am.
And Mr. Daly was previously in court, entered a plea of guilty to driving while intoxicated with a child passenger. I've received the pre-sentence report. Has everyone had an opportunity to review that report?
Yes, Your Honor.
State has, Judge.
Are there any additions or corrections?
No, Your Honor.
None from the state, Judge. The state would just ask that the court follow the recommendation.
Well, this could have been bad, couldn't it?
Yes, ma'am.
All right, so I'm going to find Mr. Daly that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, and at this time find you guilty of driving while intoxicated with a child passenger. Sentence you in accordance with your agreement to a term of 2 years in the state jail prison, but I'll probate that. You'll be on probation for 5 years. You're ordered to pay a $1,000 fine and to follow all of the rules and conditions of probation. That is going to include entering and successfully completing the JCDI program, which is an intensive outpatient treatment program. You will be required to have an auto ignition interlock device on any vehicle that you drive and comply with all the other conditions of probation. If you do that, then for all practical purposes, your case here in court is over and you'll be able to serve that 2-year prison sentence while you're out on probation. The other side of that, however, is if you violate any condition of probation, you can be brought back into court and you could be facing that 2-year sentence that you've already agreed to. Do you understand?
Yes, ma'am.
I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I've also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Kimmler. And the state is going to dismiss the other, is that correct?
Judge, my intention, the state's intention was that they run concurrent.
Can I see that pre-sentence report again? I don't, did we?
Yeah,
She's,
I got a copy of it.
I only noticed one.
the one I just did.
180 is going to be dismissed.
Yeah, the
I-
plea
I-
was,
I misspoke, Judge. I'll dismiss 0180.
yeah, that was at the,
It's whatever the paperwork reflects.
yeah, that's what the paperwork
Yes,
is. I think.
ma'am.
Okay, all right. I will sign a dismissal in 25 DCCR 0180. You need to have a seat here in the courtroom. Probation's going to call you up when she's ready to go over your paperwork. Good luck to you, sir.
I'll leave it to you.
Yes, okay.
And then Desiree Kirk's 2 cases. All right, ma'am, you're Desiree Kirk's.
Yes, ma'am.
And in cause number 24 DCCR 0518, Ms. Kirk's is charged with deadly conduct, discharging a firearm, set for trial Monday, December the 1st. And what is the announcement?
Ready?
State charges.
All right, then I will number the case. It's obviously one of the older ones. I do have a case that's already been set, especially. I can't imagine this is something that would be a very long case, correct?
It wouldn't be, Your Honor. It's
If-
deadly conduct.
Just if there's a possibility that Judge Thorne could hear it, would that be an option?
I would have no problem with that.
Okay, I'm going to number it and just see if that's an option, just based on the fact of the level of this offense and the other ones that we have. I feel like we're gonna have a hard time getting to it if I don't do something like that. So I'll let you guys know, when I number it.
So you want her back here on the first?
I'll let you know. Stay in touch with Mr. Kimler, and he will let you know if you need to be back here or potentially in another court for your trial. Okay? Okay. You're Daniel Ibarra?
Yes, ma'am.
And Mr. Ibarra was previously in court, entered pleas of guilty in cause numbers 24 DCCR 1722 and 24 DCCR 2289, both theft of properties. They were enhanced to second-degree felony offenses with caps of 10 years in each of those cases to run concurrently as the agreement. Is that correct?
Yes, sir.
I've received the pre-sentence report as well as an update report that just has some more specific information from criminal history from Spokane, Washington. Did everyone get that?
Yes, sir.
Yes, they did.
Are there any additions or corrections to the pre-sentence report?
No to the offense.
Not from the state.
All right, Mr. Kimler, you may proceed.
Your Honor, PSI reflects extensive criminal history on Mr. Ibarra, which I suppose the court could infer from the fact that two misdemeanor theft cases can be enhanced up to second degrees, which implies that he does have extensive history. The facts of these two cases are both, as the defendant indicated in the pre-sentence report, that he was under the influence of methamphetamine at the time both were committed. It's not offered as any type of exculpatory evidence or even perhaps mitigation, but it does kind of explain why somebody with this criminal history would be doing what he's doing with a laundry basket and then some items from Walmart, all of which were under, I think, probably the Class B range of the theft. I would observe that there appears to be $300 in restitution payable on one of the cases for the laundry basket. Obviously, methamphetamine, drug addiction, but for that, I think Mr. Ibarra wouldn't have been doing these types of boneheaded thefts. He's recognized that, and in counseling with him, he's done at least what I asked him or suggested that he do, and that's to go into an inpatient rehabilitation program, drug rehab program, to try to address the substance abuse issues that he suffered from really an early age, which is indicated in the report, in the pre-sentence report. That's been an ongoing thing almost his whole life, and I think he's done that, and he's I don't know if you could say terrified of going to prison, but certainly he doesn't want to go to prison, and I think he's willing to do what he needs to do to stay out of prison, to comply with any terms of probation that the court assesses. He indicates to me that he is drug-free, which obviously, if he drug tested him this morning, that could be corroborated, or not. If he's not drug-free this morning, I don't know, but I assume, I would hope that he is. And he would just like to address the court perhaps better than I, more articulately, to explain his position of why he thinks that probation's appropriate.
Are you wearing a drug patch?
No, ma'am, Your Honor, but I've been clean sober since July the 8th.
Have a seat in the jury box. Let's get that checked first. All right, sir, you're Brian Tipton, and this is 25 DCCR 0149. Mr. Tipton was previously in court, entered a plea of guilty to the state jail felony offense of solicitation of prostitution. I've received the pre-sentence report. Has everyone had an opportunity to review the report?
Yes, sir.
We have, Your Honor.
Any additions or corrections?
No, Your Honor.
Not from the state judge.
All right, Mr. Tipton, I'm going to find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney's office and defer all proceedings and place you on probation for 3 years. You're ordered to pay the $1,000 fine and to follow all of the rules and conditions of probation. If you do that, then this is an excellent opportunity because you do not have a felony conviction on your record. And if you successfully complete the probation, at the end, the case will actually be dismissed. You'll never have a felony conviction. The other side of that, however, is if you violate any condition of probation, you can be brought back into court and you could be found guilty of the offense and sent to the state jail prison for up to 2 years. Do you understand? I'm handing you the trial court certification that shows that this was an agreement that I followed, and so you've waived your right to appeal. You just need to have a seat here in the courtroom. Probation will call you up to her desk when she's ready to go over your paperwork. Yes, sir.
One request, Your Honor.
Yes, sir.
On the recommendations.
Let me see it back, please.
I believe the state's in agreement, Your Honor, but supervision plan item number 2,
Oh, I might need, what is not,
It's curfew.
It's correct.
Kristen, can I see, can I,
I have a copy.
that's okay, she's good. Thank you,
Yes, ma'am.
sorry. All right, go ahead.
On supervision plan, recommendation number 2, be inside your home every day from 10 p.m. to 6 a.m. except for employment purposes. We're requesting that we add in addition family-related medical emergencies to that, Your Honor.
Okay. Is there some anticipation that there would be something?
Yes, Your Honor. It's my understanding that the probationer and defendant's wife has had some incidents in the recent past, and it is likely and very possible that they happen in the next few months. And so we just want to make sure that the probationer is successful and that he doesn't unintentionally have any issues.
So on the curfew, it'll be except for employment or family medical emergency.
Thank you.
Yes, sir. All right, just have a seat. Probation will call you up in just a minute.
Thank you, Your Honor.
Thanks.